Sometimes, employment contracts will contain provisions that restrict an employee from competing with the company they work for after leaving the company or being fired. In the 1968 case of Wood v. May, the court considered the enforceability of a restrictive covenant that spanned many miles and years. William May served as an apprentice under Master Horseshoer Gordon Wood for 2 years. May's employment contract had a non-compete clause. For the 5 years after either leaving or being fired from working for Wood, May agreed he wouldn't directly or indirectly engage in any business competitive to Wood within a 100-mile radius from Wood's place of work in Spanaway, Washington. This radius encompassed all or part of 22 different counties in Washington, as well as parts of both Oregon and Canada. If May breached the agreement not to compete, the contract stated May could be enjoined from horseshoeing in that radius for 5 years. May became a very skilled horseshoer, eventually shoeing many of Wood's customers without Wood being there and becoming the only contact Wood had with many customers. May quit and established his own horseshoeing business 5 miles away. Many of Wood's customers felt confident in May's work and allegedly were unsatisfied with Wood, so May secured many of Wood's clients in 2 areas nearby. Wood brought an action to enjoin May from horseshoeing in violation of their non-compete provision. The court held a trial and dismissed the case at the close of Wood's evidence. The court found the time and area restrictions of the non-competition covenant unreasonable and felt the contract was indivisible, so it couldn't modify the restrictive covenants detailing the time and area. Wood appealed. The Washington Supreme Court reviewed the case en banc.